Howdy, my name's Brian Foley. I'm a criminal defense attorney and I'm the managing partner here at Houston Criminal Defense Attorneys, PLLC. We're going to be going over the Texas Penal Code. Today we're covering Chapter 1, and we're kind of going to go through the whole chapter. I'm not going to read you every piece of the Penal Code. I might do that some other time. We'll go through one by one, but I'm going to give you an overview of everything that's in Chapter 1. There's only so many chapters. You're going to see that they skip a few chapters. You're going to be like, what happened to this? Like, what happened to chapter 50? Things like that. Kind of fun if you actually read the whole code. It's very rare, even among lawyers, to have actually read the whole code. But I have, and we're going to go over some of it. So let's go over the first section, section 1.01. What do you think this is? Any guesses out there before we go in it? Here's the whole section 1.01. This code shall be known and may be cited as the Penal Code. Thank you. We have a name for the code. Okay, section 1.02, objectives of the code. So this is pretty meaningless. I mean, it says what the purpose of this code is. You could maybe argue these to a judge one day, but the general purposes of this code are to establish a system of prohibitions, penalties, and correctional measures to deal with the conduct that unjustifiably or inexcusably causes or threatens harm to those individuals of the public interest for which the state protection is appropriate. It mentions things like deterrence and rehabilitation, but there's normally a mix of those things. Mostly what happens is jurisdictions have a policy about some type of crime, and they have that for either rehabilitative or deterrence policies, and that's mostly influenced by the local politics. So like in Harris County, we've got a jurisdiction that kind of wants to focus on rehabilitation for drug offenses, but they sure will use a deterrence method if you've had too many drug cases. They won't be as forgiving if you've violated some of the terms that they've tried to give you for rehabilitation, and that's where we come in as a defense attorney and try to help out as best possible. So the next is 1.04, territorial jurisdiction. The state has jurisdiction over an offense that a person commits by his own conduct if that conduct, either conduct or the result that is an element of the offense, occurs inside the state. So if you're in Oklahoma and you shoot a bullet at your buddy in Texas and the bullet kills him in Texas, well, the result of your conduct of shooting the gun, even though you weren't in the state, they're going to have jurisdiction over you. And then let's go to the definitions. The only part that anybody ever uses as a criminal defense lawyer in Chapter 1 of the Code of Criminal, or the Texas Penal Code, are the definitions. And we use these definitions all the time, okay? The definition of an act, you have to commit an act, is bodily movement, whether voluntary or involuntary, and it includes speech. Actor, nobody really uses that. Agency, nobody's really using that. Alcoholic beverage has the meaning assigned by the Alcoholic Beverage Code. Another means somebody other than the actor. They normally say in a criminal case, there's a criminal actor, and so the actor, it's great to be an actor in real life, not great to be an actor under the Penal Code. That means you're going to get charged with a crime. So here's the first one we really use regularly, and that is definition number 8 here, and it's bodily injury. So bodily injury means physical pain, illness, or any impairment of the physical condition. And this is commonly used in assault charges. So you have assault family violence or assault on a just non-family member, a regular assault case. Most of those are filed as Class A misdemeanors because they involve bodily injury. And this is that definition of bodily injury. So when I was a prosecutor, I used to tell the jury every voir dire, we would read this definition, and we would say, look, it says any impairment of physical condition. So does that mean a scratch that's barely hurts at all, or maybe doesn't hurt at all, but just causes an impairment of the physical condition? The skin is not the way it was before there's a scratch. Is that bodily injury? You bet it is. Physical pain, we would also mention this. If something hurt, if anybody here been punched in the stomach, okay, well, did it hurt? Yeah. Did it leave a mark? No. So you don't have to have a mark necessarily because it's physical pain, illness, or any impairment of physical condition. And the illness part really doesn't come up very much. The only time we thought about bringing that up when I was a prosecutor was during COVID. And during COVID, there was a increased fear about illness, but that happened pretty quickly. We stopped doing that pretty quickly after people realized that was not, the bubonic plague. It was just COVID. So That's bodily injury. That's probably one of the most talked about definitions here. Okay, the next definition that is pretty interesting here is individual. What is an individual under the Penal Code? It means a human being who is alive, including an unborn child at every stage of gestation from fertilization until birth. And the reason they defined it as an individual here is because under the old law, under Roe versus Wade, a fetus would not be considered a human being who's born alive, right? So in order to charge somebody who intentionally kills a fetus, well, you have to charge it as an individual. So when we look at the murder statute under the Chapter 19, it's going to use the intentional killing of an individual, not a human, okay? And that is just to avoid that issue. So then we have intentional and knowing are listed in here, but it just refers you later on. Those are important, but that's going to be defined in section 6.03, the culpable mental states. Those were so important definitionally that they got their own chapter later on. A person means an individual, right, from earlier, or a corporation, association, LLC, or other entity. And that can be important when you have securities frauds, crimes, and things like that. Okay, then number 39 is possession. And this is the one that comes up maybe more than any definition in here. If it's not bodily injury, it's going to be possession. And possession means actual care, custody, control, or management. Okay, it does not mean ownership. Look, so if you have drugs in your car and you're the only person in the car and they're sitting on the passenger seat and you're in the driver's seat, you are probably going to be deemed to be in actual care, custody, control, or management. If you own a warehouse and you're in charge of managing it and it's got 5 kilos of coke in it, they don't have to show that you purchased the coke in order to charge you with possession of that substance. So really tough law there, but that's what possession means under the Texas Penal Code. The next one in line, number 40, public place. That comes up a lot in DWI cases. A public place means any place to which the public or a substantial group of the public has access and includes but is not limited to streets, highways, and the common areas of schools, hospitals, apartment houses, office buildings, transport facilities, and shops. So what about a gated neighborhood? That's a good question. The courts have generally determined that a substantial group of the public has access to that. Now, what about a gate on your property? You got 4 families on the property. I would say no. I would say that is a smaller area. But, a neighborhood that's got thousands of houses in it, if you got neighbors you don't even know who they are behind the gate, that's probably going to be deemed to be a substantial group of the public. All right, here's a good one. Serious bodily injury. So what is serious bodily injury? It means bodily injury, like we saw before, that creates a substantial risk of death or causes death, serious permanent disfigurement, or protracted loss or impairment of the function of any bodily member or organ. So good examples here, if you break your femur, okay? If you break your arm and it's broken for 3 weeks and it heals up, maybe not bodily injury, serious bodily injury, because it doesn't risk death. Okay, if you break your arm and you can't move it at all for 6 months, that could be protracted loss. Okay, if you break your femur, though, that is going to be a really long healing process. It's going to be really difficult. It's going to be significant loss there. And there's a lot of case law that just goes over this, different body parts. So like a blown orbital socket has been determined to be serious bodily injury before, but broken rib did not. And so just because you got a broken bone doesn't mean it's going to be serious bodily injury. But just because you don't have a broken bone doesn't mean it's not serious bodily injury. It's really a determination case by case. Was there that protracted loss or impairment, or did it really risk serious bodily injury or death? Like a subdermal hematoma in your head. Well, that could be pretty risky for bodily injury or death, or serious bodily injury or death. And that is pretty much it when it comes to Chapter 1 of the Texas Penal Code. That's the general overview. We will get into Chapter 2 next time, which is the burden of proof. And I hope you've enjoyed this series. If you liked the video, give it a like, give me a subscribe on YouTube, and thanks for watching.